my friend Dr. Azai. It was great to be reunited with him. I've actually represented him successfully, I might add. I used to represent the rescuers, and so part of my credentials, I'll try to get that quickly, that I think hopefully gives me some credibility, is that I founded the Pro-Life Lawyers Guild in Philadelphia in 1983, and I've litigated a lot of cases involving rescuers in the distant past. I'm also the father of 8 children, okay, which is, so I don't get teary-eyed about this. I'm an emotional Irishman, but they're all pretty close to the faith, though they have promised to euthanize me if I don't stop badgering them about getting to confession more frequently. I'm a card-carrying Catholic. I believe everything that Joe has said. I think it's accurate, truthful, and very informative. I thought I would try to start out by speaking about the Healthcare Act, what it does, comparing it to something that I do a lot of, which is estate planning, and specifically property powers of attorney, how they differ, okay, and what the purposes of the Healthcare Act is. The Healthcare Act went into effect in 2007. It was passed in 2006. It's Act 146. It's contained in 20 consolidated statute annotated, which is the probate code, the probate estate and fiduciary code. Also in that section are all the property documents, estate planning, wills, things like that. And it's very interesting. Let me start out by comparing, like I said, those documents. First of all, property powers of attorney and healthcare powers of attorney. Property powers of attorney require an acknowledgement by the agent. And by the way, Joe used the term proxy, surrogate. In the statute, we call them healthcare representatives. That's what they are under Pennsylvania law. That's what we discuss them as. Okay. For property powers of attorney, they're agents. The agent has to acknowledge his or her agreement that they will act as the agent under property powers of attorney. And by the way, this is a little bit off subject. I tell people, this is a public service announcement, but also some self-serving comments here. I tell everyone that they need 4 documents as an estate planning attorney. They need a will, they need a property power of attorney, they need a healthcare power of attorney, and I still think that they should have a living will, okay? And we're going to talk more about that. And I can tell you that if you do not have a property power of attorney, okay, you're forced to have a guardianship. With a healthcare statute, you don't actually have to have a healthcare representative named. There's a default, okay? And I think this is probably based upon the fact that there's more immediacy required, that if somebody doesn't have a healthcare document, then family members have to act in that capacity. And what happens in the healthcare arena is that the spouse and the children have an equal right to act as the healthcare representative. You look like you're confused, Joe. Did I say something incorrect? A beeping? Oh, gosh. Huh. Maybe I should take this. Okay. Okay. Yeah, okay, so it's good. So getting back to those 4 documents, it's so critical for an elder law attorney to make sure that a client has a properly executed property power of attorney, okay? And what's the reason for that? It's very germane to our discussion here today. Because of the advances in medicine, people live longer. They live longer. However, they still get sick. They get strokes, they get dementia. And my business is thriving, unfortunately, because of those facts. Just a little biographical part of my career as an attorney. I've been an attorney for 48 years now, okay? The first half of my career, was spent as a trial lawyer. I was a plaintiff's trial lawyer. I tried large products liability, medical mal, slip and falls, auto accidents, the whole gamut. And after our sixth child was born in 1994, my wife said to me, look, you're tied up, you love doing all this litigation, you're tied up doing it, but I kind of need you more here at home to take care of the kids. So I said, sure, hon, you're right. So I agreed to matriculate into this area. This is 1994. And right at that time, elder law was beginning to be recognized as a discipline in the law. And I consider elder law to be a subset of estate planning. It's more sensitive to the needs of elderly people, and particularly in qualifying people who need long-term care for Medicaid, okay? Elder law attorneys have techniques to preserve assets from having to be spent down to qualify for Medicaid, okay? Typically in Pennsylvania, you either have to spend down to $8,000 or $2,400 to qualify for Medicaid, okay? And typically, nursing home monthly bill is about $18,000. So in 10 months, you've gone through close to $180,000. So critically, and I say this, I tell every audience that I've ever spoken to, I will look, and I have my cards and my information here, I'll look at anybody's power of attorney for free, okay? Their property power of attorney, to determine whether or not they have broad gifting provisions, because they're necessary to do this Medicaid planning that I'm speaking about. The law is great in Pennsylvania. If you're married, we can save almost everything, okay? If you're a single individual, we can usually save about half of the assets. So, in any event, let's move on now to a discussion of the advance directive. In the statute that was passed in 2006, went into effect in 2007, the durable health care power of attorney and the living will are considered advance directives together, okay? Lawyers tend to look at them. In my own document, I combine both the durable health care power of attorney and the living will, okay? And probably the motivation, which was a good motivation for doing this, for having this new statute, was to allow patients to not to predict, but to select what kinds of care and treatment they were going to receive in the event they became incapacitated, okay? Obviously, you don't need that if you're able to make the decisions yourself, okay? The question is, do you have the legal capacity to make decisions for yourself? And if you don't, you need a surrogate or a proxy or what we call the healthcare representative to make that decision on your behalf. And let me draw a line here, okay? I want to talk about euthanasia. I really want to discuss, if we have the possibility, Joe, today, to talk about some of the philosophical underpinnings of the church's teaching and where we are today, okay? But everyone agrees that, and we'll call the people that do not agree with our perspective, okay, which take a transcendent view of life, I will call those, for the purposes of our discussion today, the secularists, okay? And we the people here, will call, who are sympathetic with the Catholic perspective, which is essentially a natural law perspective, I'll call the realists. We'll get back to that. But everybody agrees that the person that you select as the healthcare representative needs to be on the same page that you're on when it comes to care and treatment. And that's really important, okay? And we run into this a lot in the office. Parents typically do not want to offend their children, okay? They don't know who to select. And I will typically say, well, look, we need to find somebody who has the same perspective as you, okay? Who has some savvy, who can communicate well with healthcare professionals when the time comes, and that isn't going to be persuaded, okay? And you shouldn't worry about, where they are in the pecking order. You want to select the child who can do this best. Typically, it's the spouse, if the spouse is alive, okay? So that's really important. really important to have in the healthcare document somebody who's going to act in accordance with your view, okay? As I mentioned, the other, and again, it's interesting, I think that, and I've said this before, I think, we don't have to have a document for a healthcare representative to act under the statute, whereas you do under the PEF code when it pertains to the property power of attorney. And that pecking order is really important, and that's why it's a good reason to have this document, because if you don't, there may be people who you don't want to make those decisions for you acting based upon how the statute enumerates the people in descending order, okay? It's your children, then it's other people, grandchildren, parents. So by creating this document, you can get a person who is sympathetic with your viewpoint to act, okay? Let me turn for a second to the living will portion of the document. Almost everyone, the secularists included and the realists, feel that there are real issues with the living will. And by the way, a lot of people confuse a living will with a regular will. I prefer to call it an advance directive as distinct from a healthcare power of attorney, okay? And the problem, and Joe asked me to point this out, and I certainly will, the issues that come up with the problems that come up with the living will, again, let's call that the advanced healthcare directive, are that it probably tries to do too much, okay? And you see the ones in the hospitals all the time, they have specific things that you can elect or not elect. And that presents a problem because treatment of health situations is fluid, okay? Things can change, okay? So you don't want to tie things down. And it does, the Pennsylvania form that's used allows the healthcare representative or you to select that you don't want hydration and nutrition, which is certainly contrary to Catholic dogma, Catholic teaching. By the way, I feel like I'm a little disorganized here, and I'll tell you why. I'll share this with you. I'm very busy. I've had a back issue, and I went into a flurry to get caught up in this area. Most of our work, I would frankly concede, is more directed on preserving assets and looking at property powers of attorney and wills, okay? So I feel like I've assimilated so much information. I went to a webinar on Tuesday that the Pennsylvania Bar Institute put on, and this is where I've come up with this distinction between secularists. And euthanasia is here, and it just keeps, making a further move closer and closer to us. By the way, I'll say two things on this point. I found out yesterday that the American Medical Association, Joe, I don't know if you were familiar with this, for the first time in its history, withdrew its support of being against medically assisted suicide. First time, okay? This is a national board, the American Medical Association. Ever since Dr. Gevorkian back in 1993, the American Medical Association has stood strong against euthanasia and medically assisted suicide. Now they're taking a position of neutrality. And as one of the representatives from our side said, in all 10 states in the union where they permitted, Oregon, the District of Columbia, Washington State, this was always, the medical profession said they agreed that there wouldn't be any more opposition to medically assisted suicide. So I have a question, just going to interrupt, and Joe, you can't answer this. I've got to ask everybody else. What's the first principle of the natural law? Can anybody tell me? What is it? Somebody raise their hand and tell me. In a sense, that's not the answer I'm looking for. If somebody else can't answer it, I'll have Joe answer it. I don't want to embarrass you, Joe. You better give me the right answer. Preservation of your life, right? One of the nice things about Catholic teaching on this subject is it's all of a piece. It articulates the natural law, and all these things are directed toward preserving your own life. That's what the teaching of John Paul is. We're trying to preserve our own life. And the threat with euthanasia and all these opportunities with PULSed is that you're not going to do that. There's a subtle influence to persuade people that, enduring suffering, continuing your life is not necessarily a good thing depending upon the circumstances, okay? The other issue, I think, Joe, that we wanted to cover on the living will, besides that these selections and the withdrawal of treatment, is that there has to be informed consent. Has to be informed consent. People, when these people are signing this living will in a hospital, they're asked to check off boxes. There's no meaningful discussion about what's going on. There really isn't. They just kind of shoot from the hip. Oh yeah, I want this, okay? And that living will gives, I think eventually the healthcare provider an opportunity to practice euthanasia. I think we're getting closer and closer to that, and it's very scary. It really is. So I don't know whether I should open up to questions at this point. I learned an awful lot. I know about PULSed. What I asked Joe this morning, I said I think I was having the synapses weren't working really well. The word I was looking for was euphemism. They call the PULSed, for example, the physician order of life sustaining treatment, okay? Well, again, that's an opportunity to shut the door, okay? Not to preserve your life, to cut off legitimately life-saving treatment. And you're seeing this all the time. It's social engineering by the use of language. And there's an effort now, there's a bill that's been introduced for the 11th time. It was introduced in March of 23 in the Pennsylvania legislature, which is going to ratify physician-assisted suicide, okay? And fortunately, we've been able to not go that route so far, but it's just getting closer and closer. This seminar, this webinar that I attended on Tuesday, the physician there was a savvy guy, but he was essentially a secularist. He thought that, starving yourself to death was an acceptable form of treating, okay? And I hate to be accusatory or blaming, but the problem is that these people come from a totally different philosophical perspective than we do. They do not appreciate the transcendent meaning of life. Joe had pointed out Evangelium Vitae, some of the teachings of John Paul II. What I would point to, okay, is his magnificent apostolic exhortation called Salvifici Doloris. If you haven't read Salvifici Doloris, you should, you need to, and it's on the Christian meaning of suffering. We see suffering, the realists, as something to be sanctified. We're willing to unite our sufferings with the cross. The secularists view suffering as something totally senseless and unnecessary, and it's to be avoided at all costs. And unless we can persuade those people that we're right and they're wrong, that suffering can have meaning, their anthropological perspective is not a genuinely correct one, then we're going to lose the battle. We're going to lose the battle. So we need to proclaim the truth loud and clear. I have such praise for the National Catholic Bioethics Center. A friend of mine, John Haas, as Joe had mentioned, was instrumental in finding it. And he's done a great job. And these issues have to be, thank God we have a resource like the National Catholic Bioethics Center to resolve these questions, because they become very difficult. As Joe points out, with the technology advances, there are real tough questions that need to be answered that people don't know the answers to. They don't know what the Catholic response should be. And the National Catholic Bioethics Center really does a great job in helping people, helping physicians, helping people address those answers, because they're very difficult. I think I may have said enough, okay? I feel like there's a lot more that I could say, but I would like to open it up to some questions and answers. So go ahead and shoot. Yes, go ahead.
What were you talked about the 4 important documents.
Yes.
The 2 that we should check, and I have all 4, but you're saying we should double check.
You should double check your property power of attorney to make sure that it has broad gifting powers. Okay, and that's a little, you know, I'm just saying that as an estate planning attorney. What we want to focus on here today are the healthcare documents, which are the durable healthcare power of attorney and the living will, okay? And let me say this, I want to express a debt of gratitude to Joe. I asked him, my healthcare documents are actually a work in progress. I had submitted to him for his review earlier in the week 3 documents that I have used, okay? And he gave me some very helpful advice. He kind of patted me on the back with something that I came up with, and I'll share that with you. But for example, one of the documents that he had referred to, he doesn't remember, but I'll remind him, is the Pennsylvania Catholic Conference document, okay, which is really not acceptable. Okay, because it does open the opportunity or provides the opportunity to withdraw hydration and nutrition. Okay, and I don't want to blame them too much. They're basically following the statute, Act 146. That's one of the provisions. In the version that I showed Joe that I use basically now, I had removed that. Okay, and he sort of said, "Yeah, Jerry, you're on the right track here." But anyway. I want to just point out one of the provisions that we put into our living will. And then I want to, actually, before I go to questions and answers, I want to talk about one other aspect of all this. So just give me a sec, if you will. Joe, I don't know what influence you have in maybe contacting the Pennsylvania Catholic Conference to getting them to alter that document. Because, as Joe pointed out to me, the problem with these documents are that they open the door to material cooperation with evil, okay? And that's a significant concern. I, in my own naivete, included these possibilities because they were in conformity with the statute. But again, there's no reason why we have to include those provisions just because the sample language of the statute provides for them. Okay. So anyway, the language that I utilized. And it's difficult. You know, we're draftsmen too, lawyers, okay? We have to tailor-make. I mean, yeah, sure, we use templates and things overlap and things coincide. We can use other people's documents as templates. But in this particular area, it's really important to get it right and to come up with language that is not going to facilitate euthanizing people, okay? Here's what Joe commented on. I have guidance for healthcare agent. If I have an end-stage medical condition or other extreme irreversible medical condition, my goals in making medical decisions are as follows. And I have palliative care. Nobody objects to palliative care, by the way. Okay, nobody objects to that. Palliative care, including hospice. However, I do not wish to receive any form of care or treatment that has the direct intended effect of taking my life by the delivery or administration of drugs or the withholding of ordinary care. And again, ordinary care in most circumstances is hydration and nutrition, okay? So I think my goal as a practicing Catholic attorney in this area is to facilitate moral choices and to prevent immoral choices and to you know, counsel people as to what should be done. And you know, my education as a lawyer, you grow in your experience. I once thought incorrectly that the feeding tube was an all or nothing proposition, okay? And it's not, okay? The natural law analysis, at the heart of it, is does the benefit outweigh the burden in the circumstances presented, okay? And as Joe mentioned, you know, if somebody's going to live for 72 hours, and we know that pretty much, and then it's going to be over, it would be burdensome in most circumstances to affix a feeding tube. If a person has cancer of the stomach and the pain that would be experienced, I don't know if that's a really good example, okay, but there's no moral obligation in that present situation. I shared with him one of the examples that I utilize a lot, why people should have hydration and nutrition. Sometimes you really have to persuade them sometimes, is that if somebody has a very significant operation, okay, where their life is literally hanging in the balance, and they recover and it's successful surgery. If you say no to hydration and nutrition, guess where that's probably going to go, okay? And you can query, why have this operation in the first instance? Why have the operation in the first instance? So in any case, let me just look at another provision that I added here. This healthcare power of attorney, I'll go back to that point again. I apologize, I'm a little disorganized. And I feel I have so much knowledge, I want to assimilate it all. I've learned so much in the past few days. These are the things that the statute does recommend that an healthcare agent can do. And remember, this document is only effective, the durable healthcare power of attorney, when you can't do these things yourself, when you can't make these decisions on your own, okay? And you need somebody to authorize, withhold, or withdraw medical care and surgical procedures, to authorize my admission to or discharge from a medical, nursing, residential, or similar facility, and to make agreements for my care and health insurance for any care, including hospice or palliative care, to hire and fire medical, social service, and other support personnel responsible for my care, to take any legal action necessary to do what I have directed. HIPAA, okay, being able to move documents from one care provider to another. You really need a healthcare representative to do that, and you want to select the right person who is going to effectuate that for you. Let's see if I can find the other point. In my preparation for this, I looked at the homicide statute, okay? And I looked to see whether or not there was a law against suicide. And remember, suicide is morally reprehensible. That's a bold statement to make. It's violative of the Fifth Commandment. Now, obviously, okay, if I can draw an analogy here, we typically don't prosecute women who have abortions, okay, because we see them as victims. And by analogy, we don't prosecute people who have committed suicide because we can't, they're deceased, okay? But how about attempted suicide? The reason we don't prosecute people that most of the time that attempt suicide is there's not a statute but that permits that in Pennsylvania, but compassion tells us most of these people are emotionally distraught because of depression or whatever, okay? But I think it's important, I think the legislature should enact a law saying that self-homicide, suicide, is against the law, attaching perhaps punishments to that. And that's a radical position to take, okay? But I think one of the reasons we want to do that is we want to say, look, it's possibly a deterrent. And by the way, in American society, if it's the law, it's moral. If you're permitted to do it legally, okay, then it's the moral thing to do. That's just the way we're programmed in this country, okay? So if we have laws against suicide, okay, hopefully it will act as a deterrent, okay? We would probably never prosecute those people. Now, it is a law, very interestingly enough, to assist people to commit suicide. let me just. Let me read the criminal statute, okay? And it's very interesting in this movement towards euthanasia. They're trying to erode this. They're trying to erode it. Here's how they're trying to erode it. Death, not suicide or homicide. Withholding or withdrawal of life-sustaining treatment from a principal or patient resulting in death, in accordance with the provisions of this chapter, shall not for any purpose constitute suicide or homicide. Okay? Again, I apologize for my. Is that the current law? Yeah, that's the current law. That's the current law, and this is also the current law. Okay, so it's difficult to harmonize these. If I can just get my hands on it here, hold on. Here we go. This is section 2505 of the Crimes Code, Title 18. Causing or aiding suicide. A, causing suicide is criminal homicide. A person may be convicted of criminal homicide for causing another to die by suicide only if he intentionally causes such suicide by force, duress, or deception. But B says this, aid or soliciting suicide as an independent offense. A person who intentionally aids or solicits another to die by suicide is guilty of a felony of the second degree if his conduct causes such suicide or an attempted suicide, and otherwise of a misdemeanor of the second degree. So I think B is a little more broad and doesn't provide the loophole that A provides. So if you're assisting somebody, I think a doctor could be prosecuted under this. Yes?
Well, places like Canada where euthanasia is becoming horribly prevalent, I think people they're emotionally vulnerable.
Yes.
And they're being literally led right to committing suicide and guilted into it by, oh, you don't want to do this to your family, your life's not worth living, or people that really have very temporary things. Children are being euthanized.
Absolutely. And this is where we're going. I heard this at a talk given at the annual First Things discussion. 1 in 20 people who die in Canada, it's a result of medically assisted suicide. 1 in 20. Okay? Yeah, it is. It is. This bill that was introduced in March of this year that's going to permit assisted suicide, you know, I mean, it's the 11th time that they've introduced this bill. Okay? So it's really scary. And very interesting, this physician, he's out in Susquehanna County, he was making a big distinction about allowing people, by giving them, you know, drugs that they can self-inflict themselves versus lethal injection, okay? And he says, oh, you know, that's the slippery slope. I don't think that's much of a distinction at all. They're only getting the medication, forgive me, bite my tongue, it's not medication. They're only getting the poison to kill themselves from the physician in the first instance. What's the big difference if he just injects them, okay? It's not a watershed event. So I think this is something we really need to pray about and almost evangelize on. And this is the next anti-life frontier that we're faced with today. Go ahead.
Do any states have laws against that?
Well, so
What you said you think they should do, but
they should do. You know, I haven't had really a chance to research it. Pennsylvania does not. They only have a law prohibiting people from assisting, you know. And, you know, what DA would prosecute that today? Nobody, given the mood and the culture that we live in. But am I done?
We're going to have a Q&A in just a moment.
Okay.
Anything else you need to cover?
I think I've covered everything. And again, I apologize. I'm a little disorganized. When I tried cases, go ahead.
What is the POLSP? I never heard of that before.
Yeah, we talked about physician order for life-sustaining treatment. That would happen, I'll tell you when it happens. It happens when the EMTs come to your house. It doesn't need to be signed by a physician. It only needs to be signed by a physician's assistant or a certified nurse practitioner. And again, this is the euphemism that we're talking about, okay? They call it a physician's order for life-sustaining treatment, and it's really a document that permits them to check you out by not administering basically ordinary care.